that report. And any additions or corrections or speak up, I'm sorry. I've got one, two, three, and a quarter pages of criminal history. Well, there's a lot of stuff that wasn't dismissed. There were 14 felonies that weren't dismissed. At least 4 or 5 misdemeanors that weren't dismissed. I understand the restitution, and y'all know my position on that already this morning, but this...
And here's the moment everything shifts. When a judge says 1, 2, 3 and a quarter pages of criminal history, that's judicial code for. Your credibility just collapsed. Prior cases, even dismissed ones, matter when deciding whether someone deserves leniency.
She's on probation right now in Sutton County, correct? Right. So do they know about this case? And what has happened over there, if anything? I can't understand you. When? Are you really going to be able to go to nursing school with this type of criminal history? Where do you live now? Another issue that I see on here also is the restitution, because it shows $9,400, but then that was from inside the...
This question hits hard. Can you really go to nursing school with this record? That's not sarcasm, it's reality. Certain professions demand trust, and theft cases strike directly at that. The courtroom tension here is about future consequences, not just past mistakes.
Bank, and then it shows $500 from an ATM and $100 from a cash app, totaling $10,000, not $9,400. Is that correct? Well, it says 500 was withdrawn from an ATM outside. Is that right? You know better than anybody. Okay. So possibly the other person that was involved did that? Right. It says, so the contact from Do Good said that the defendant withdrew the entire loan amount of $10,000, $94 from inside the bank, $500 from an ATM, and $100 from a cash app transaction. It doesn't matter if you did it or the other person that you were with did it. Y'all were working together. So you're both, and what's the other status of it?
This is a key legal lesson. It doesn't matter who physically withdrew the cash. In joint criminal activity, everyone owns the total loss. Courts don't divide blame, they divide responsibility.
Okay. Yeah. So if there was another person, you didn't give that information, then that's okay. Apparently the cops didn't either, so. Hey, hold on. So the probation's in Sutton County. Have they been transferred to Harris County? So you're going in person in Harris County. Okay. And so the state's position to go forward with the agreement?
Stand for sorry for me, yes. See, I'm still like that.
So, all right. So here's what I'm going to do, Miss Logan. I'm going to find that you entered your plea of guilty freely and voluntarily. Can y'all hold it down over there, please? I'm going to find that you entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. I just don't know. I just can't believe I'm even considering doing this, honestly. I'm not. I can't. There's no way. It has to be straight probation. And I realize that that's going to potentially have some issues, but I can't with 14 prior felony offenses, same type of things.
Whoa, this is rare and powerful. Judges usually accept negotiated deals, but here the court says no deal. Why? Pattern behavior. Same crimes, same playbook, different years. At this point, probation looks less like rehabilitation and more like a gamble.
So, you do?
No.
Okay. How many do you think you have? Okay, you have lots of them that were at the same time for different. Yeah, you did probations for that. Yeah, forgery of a financial instrument. March, don't talk over me. March 3rd, 2008, Harris County, 180 days in jail. So that one was reduced. March of 2014, forging identification cards in Cuyahoga County, Ohio, 1 year probation. And same charge, same probation, so that's 2 in Ohio. March of 2014, aggravated theft in Ohio, another probation, the same date, but still another charge. March of 2014, attempted drug possession, pled guilty, 1 year probation. March of 2014, same thing in Ohio, possessing criminal tools, probation, all that was at the same time, but still different cases. November of 2014, forgery, 2 cases, got probations in those. I'm going to run out of fingers. March, another one, a theft, aggravated theft in Ohio in 2014. Then we go to Sutton County, Texas, and you have 1, 2, 3, 4, 5 continuous smuggling of persons for pecuniary benefit, and that's the 10-year probation that you're on in 5 different cases. That's not correct.
No.
So how many cases are you on probation for in Sutton County?
It all ran.
I understand it all. It doesn't run. That's not how it works.
Yes.
When it runs together, it just means you're serving it at this. I'm rejecting the plea agreement. I'm resetting your case for 3 weeks. We'll see you back in 3 weeks. Y'all can talk about it then. You're at, ma'am.
What?
This is not going to help. Well, looks like you did that, not me. I'll see you in 3 weeks. What you say? Come on, hold on, dear. Don't let her go. Come back. Everybody heard it.
You're bullshit.
Come back. You don't talk like that to anybody in this case because he didn't do this either. You did. He did get you. He did a great job.
And this is where emotion costs real money. Courtroom attitude de metteurs. The moment the defendant lashes out, the judge shifts from negotiator to enforcer. Raised bond isn't punishment, it's control. And once that switch flips, there's no undo button.
Oh. I'm going to find at this time that your bond is not sufficient because of your attitude and because of your Well, maybe you shouldn't cuss at your lawyer. Maybe you shouldn't have this attitude here in the courtroom. I'm going to raise your bond. What's the block? Right now, after saying it's bullshit to him and acting like this in here, stop. No, you're going to make it worse. You're just going to make it worse. You should, when I told you a minute ago to stop, you should have stopped when I told you to. All right, I'm going to set your bond at $25,000. Go back with the paper.
So here's the takeaway. Court isn't just about what you did. It's about how you act, what you've learned, and whether the judge believes you'll stop. Miss that balance, and the consequences escalate fast.